Welcome everyone, this is Amore from Margie Pienaar Estates, and today I've got Werner Durand from Van Rensburg Inc. Welcome Werner, just quickly tell us a bit about your company.
Amore, thank you for the opportunity and selecting our firm to join this telecom today and the recording that we're going to broadcast. Just quickly, Van Rensburg attorneys, we are situated a stone throw away from the Queen's Park or the Queen's shopping centre in Queenswood, just here in Hatfield, easy accessible from the highway and in the centre of Pretoria. That's where we are situated. We've been around since 1993, specialising in property law, new township establishments, sectional title schemes, openings of that. We do litigation, and the topic of today, we've got a deceased estate department as well.
Great, yes. Today we are going to tackle something that people don't really talk about, but I think when this happens, everyone have to deal with a lot of issues regarding a lot of pain because you lost someone, and now you've got to deal with someone that did not have a will or testament. So we thought it's very important because I also sometimes get people that sit and we hear a lot of sad stories where people just were in situations where if they had a will and testament, this would have never been the case. So they have to deal with all of this situation and loss and now all the paperwork. And we all know will and testaments, a lot of paperwork, long time.
No, for sure. For sure. So, as I've mentioned, we've been around a long time, and during this time, we've seen a lot of heartache and pain, just due to the fact that the deceased did not make provision of what should happen to his assets, and specifically in this case to his immovable property. So very important that you do make the correct provision for that.
Yeah, you tend to plan for a lot of things, but this is one thing you don't plan for. So that brings me, that brings me to my first question is, what happens to my property if I pass away, if I didn't have a will?
Well, Amore, the first thing is, let me start out by the drafting of a will, very important. If you don't have a will, what would basically happen is your deceased estate will be administered in terms of the interstate succession law. And that would then devolve to your next of kin. So basically, by law, they will select your nearest next of kin, and the property will be transferred to that person. Now, we always think that it is important to have a will, and if you don't have a will, then your property would go to your next of kin in terms of the interstate succession law. But you also have to make sure that if you do have a will, that it's a valid will, and that's where we as attorneys come in. If you take a shortcut, you think you can do it yourself, or you print something from the internet, you often make legal mistakes that are not acceptable, and once you submit the will to the master's office, it's not accepted and rejected, and then your deceased estate will be transferred in terms of the interstate succession law.
I think we see this a lot. We see a lot of people that, especially with property as well, that think it's an easy, let me quickly do this myself. And I think this is one of the things where your DIY, I'm also a DIY person, but this is one place where DIY won't work, because I have seen a lot of contracts where people have done a DIY, and because I'm a trained eye, I can see where the mistakes were made or where they didn't protect themselves thoroughly. And I'm sure that you also have seen this a lot of times.
No, for sure. As I said, the biggest pitfall would be that the master does not accept the will as a valid will.
So my next question to you is, what will happen to my property if I bequeathed it to a specific person in terms of my last will and testament?
Well, if the will is accepted, as I've mentioned now, then it's fairly easy. The master of the High Court would appoint the executor, and the executor will have a fiduciary obligation to transfer the asset, in this case, the immovable property, to the person who it has been bequeathed to.
And if I did not have a last will or testament, or my testament is invalid, what will happen to my property?
As I've mentioned earlier, the property will be transferred in terms of the intestate succession law to the next, your closest next of kin. But that would be determined by the master and your executor. You will have no say in terms of a will over that.
So that just basically means that if it will be passed on to my next of kin, even if I decided I wanted to bequeath it to someone else, I will have no say in it.
100%.
Yes. So what will happen if I bequeath my property to a specific beneficiary, but the property is still bonded? What will happen then? And I think we discussed this as well. And I just want to jump in there and quickly just say from my side, I've also seen this a lot of time where property have been bonded. And now someone have to apply for a bond, and they should be willing and able to pay the installments of that bond. And this is where I've seen a lot of sad stories, and I think you as well, where people, if it's a husband and wife team and maybe the husband passed away, I've seen this a few years ago where the wife was very saddened because she on her own could not afford this property. But because she did not have the means to afford this property that she's been staying in for quite some time, the bank just said, well, you have to either qualify for the bond and pay the installments, or you have to move out and we have to sell it. And that's one of the saddest, I want to say, sales that we do, is one of those.
Yeah, 100% correct. I think you've answered the question yourself, 100% correct. And I think the provision that you can make for that, especially if the heir that would inherit that property does not have the financial means to buy the property or to settle the bond, is as the main applicant when you buy a property, if you are a shared owner, to make provision in terms of insurance. There are several insurance products on the market, bond protectors, specifically just for the time of your bond. Let's say it's for a 20-year bond, you take out bond protection for 20 years. It's not life cover, it's only bond protection for 20 years. And during that time, should you pass away, that insurance, that bond protector will pay out and settle your bond, and the property can be transferred unencumbered to the heirs. So they can get the property without it being bonded, and the bond protector will settle the all outstanding debt with the bank.
Yes, and I think it's one of those things is if you just take a little bit of time and talk about the things that are uncomfortable, you can save your loved ones so much heartache afterwards.
No, for sure. And you have to think about these things. And that's why we've got a drive at our firm for our clients presently, where we say during the normal run of life, life is so busy, you don't get to do your personal things. You don't have time to do your personal things. But use this time now during lockdown to draft your will, to get your bond protector insurance in place, and to make sure that your personal things are in order. Because as you know, these things normally get left behind in the normal run of life. So take the time that you do have now. Think about your will. Contact us. We will assist you. We are a level 4 essential operator. So we're open for business. I'm at the office now, and we can do your will. We can assist you with that.
Yes, and I think that's very important to mention, because I think a lot of people have time, but there is so much fake news doing the rounds that it's good to hear it from people like you that are informed and that know it. And it's a good idea just to, while people have so many questions and while they sit at home, your lines are open at your work. You can answer all of their calls and you can do this. Everything we can do now is online. If it was 10 or 15 years ago, we would have all be like, it would have been a total different situation. But because we are now in such a digital world, they can call you and you can have like we're having now, a Zoom meeting with them, hear what their specifics are and their needs are, and consult them either via Zoom or on phone and do a testament for them or a will for them, which will save them so much trouble afterwards.
Agreed, 100%.
I think it's like you said, we in Gauteng we're such run of the mill people that we are so concentrated on issues that are non-issues. If something happens to you, you died without a will, that this is important to think of, especially now in lockdown.
Yeah, for sure. I agree.
So my last question to you is, what will happen to my property if I am like a co-owner of the property? What will happen to my half of this property if I pass away?
Well, again, we go back to determine if there was a valid will, or if the property should be bequeathed in terms of the Interstate Succession Act. But in short, your half share or 1/3 share, or how big your share might be, would be transferred in terms of the will to the heir, or to your next of kin in terms of the interstate succession law, subject to the bond and finance being settled, as we've already discussed. So also an important point to take into consideration is, if you bequeath that share to somebody, will they be able to jointly operate and manage that property further on? Will they be able to work together as partners in that property further on? So things to take into consideration when you draft the will.
Yes, and I want to ask you one more question is, say for instance, I'm an elderly person or matured in age, and I had kids, and say for instance, my daughter or my son was married to someone, and I bequeathed that property to that specific child. And say for instance, they were married COP. Does that mean I automatically bequeath that property to my son or daughter-in-law as well?
Yes, Amore, it's a very valid point that if you do not want to do it like that, you have to specifically mention in your will that you bequeath this property excluding the community of property of the existing marriage, so, or in any future marriages. So yeah, if you want to make provision in that case, definitely you have to mention it like that. Otherwise, it fall into their joint estate, being married in community of property.
Yeah, and what I've heard you say quite a few times now, Werner, and I think it's very important to say this, is you have to say this specifically in your will. You have to say this specifically if you want this to happen. If you don't want decisions to be made on your behalf as if you took them, you need to take these decisions now and write it down and consult with an attorney that can help you with this. Even if you have a will and testament now in place, go and have a look at it again, because what will happen is, if you do die, you will leave a lot of heartache and mounds of paperwork to people and decisions that was made on your behalf if you did not want it. So that's what I hear you constantly saying.
100% correct. No, and it is important, you know, we've at our office, we've got a system in place where we review our clients' wills. So once in 2 years, we contact them, say, listen, is this still the position? Because things do change. You know, people get married, they have children, people pass away. Some of your heirs might pass away. Your children might be minor at the time that you draft the will, but a few years later, they might not be minor anymore. So things change. You have to update the will constantly.
Yeah, and I think it's very important. So my advice would be to make sure that you go to an attorney. The advice that we give on this platform is merely advice that we can only stretch that far, because we cannot answer individual questions. So that's why it's best to go and see the attorneys. And I really would like to thank you, Werner. And if anyone wants to come and see you guys, van Rensburg Inc, thank you very much for your time.
Amore, thank you for the opportunity, and we'll speak again.
100%. Thank you. We'll definitely do it. Bye-bye.
Thank you. Bye-bye.